Sam Seder, Emma Vigeland on the Majority Report. Joining us now, David Bacon, author and journalist, focuses on labor issues, has a new piece in The Nation magazine, Big Ag's latest blow to worker rights. David, welcome to the program.
It's a pleasure to be here. Thank you for inviting me.
David, give us some background on this AB 2183. This was a big deal, and Gavin Newsom was a little bit reluctant at the time to sign this law. But tell us what this law does.
Well, this law is called the card check law because what it does is it allows workers to join the union and to organize a union by signing what are called authorization cards. In other words, they're kind of like union membership cards outside of work at home. And then when a majority of the workers in a particular workplace have signed those cards, then the union can present them to the Agricultural Labor Relations Board, which is in charge of California's agricultural labor law. And if the board certifies that, in fact, a majority of workers have signed those cards, then it certifies the union as the bargaining agent for those workers, which means that the union then has the right to sit down with the grower and bargain a contract.
And this is what we, I guess it was, maybe it was in 2008. This is what card check, there was an attempt to do this on a national level. We now, in the wake of the Cemex case in the National Labor Relations Board, have a similar, it's sort of like a card check light, where it's simply and the theory behind this is that by just having a card check and not having to have a file for an election and then have the election 3 months later, that it doesn't give the management the opportunity to union bust and bring in their lawyers and, make the union sound like it's some type of a nefarious organization. My understanding, too, is that this law also has a provision that if there is no contract negotiations, once the union's certified, if there is no contract negotiations or if management stalls, which we're seeing a lot now on a national level, we've had a rash of of union certifications, and Starbucks just after a year agreed to finally sit down. But this is the way they do it. They string it out so that people become disenchanted with the union because they're stonewalling the contract. Under this law, my understanding is that it automatically goes to arbitration after a certain period of time.
Yes, you're right. We need a little bit of history here. California passed the Agricultural Labor Relations Act in 1975, and Jerry Brown, who was our governor then, signed that law. And this was the first law that gave agricultural workers in the United States the right to bargaining, because ag workers were excluded from the national law when it passed through Congress in 1936. So the law set up a process for workers to organize the union and to vote and to negotiate a contract. So the first problem was that even though workers voted for the union very often, growers would refuse to negotiate a contract. So the legislature in California passed a second law in 2002, which is called mandatory mediation, which does exactly what you're saying. So that when workers choose their union, whether in this case by card check or in the old election process, and the grower won't negotiate, then the state, through the Agricultural Labor Relations Board, can essentially, first of all, call in a mediator, and then if the grower still won't agree, impose a contract on the grower, a first-time contract. Now we have a third modification to the law, which is the card check law. And I do want to point out, actually, that public employees in a number of states do have a card check process in which they can sign cards, and then the public entity that they're working for sits down and bargains with them. Public employee, labor relations are not quite the hardball sort of labor relations that you have in the private sector, and certainly not in agriculture, which is probably more hardball than anywhere. So really, this law that we have in California was passed in order to cure previous problems. And the problem with the election process is exactly what you're saying. In fact, the National Labor Relations Board has said now that, for instance, captive audience meetings, which do what you're talking about, are not really legal any longer. Companies are not supposed to do them. In California, we haven't gotten there with this farm labor law, so there's still captive audience meetings going on, and the law is intended in part to kind of take that into account.
Is there any other like full-on card check law or provision to force arbitration in the event that there's a determination that the management's dragging its feet in some way, and I guess it maybe constitutes an unfair labor practice? Is there any laws like that on private in private industry in any other context around the country, or is California sort of leading the way in that?
Well, actually, New York State now has a card check law for farm workers. The process is somewhat different because in New York, there wasn't a previous law which has been modified, and which is what the process has been in California. So there is a card check process. In fact, growers are going to war sort of against the law in New York State at the same time as they're going to war against the law in California. And the National Right to Work Committee is kind of directing these national efforts against that. In the private sector, unions often try to get companies to agree to neutrality, which essentially means that the company will no longer campaign against the union and will accept the authorization cards as proof of majority status and will then go on to negotiate. That happens, for instance, in the hotel industry quite a bit. But to get a company like the Marriott Corporation or Hilton to the point where they agree to neutrality, that's the problem. Once they agree to neutrality, the card check is kind of like a pro forma way of showing that the union has majority support.
So let's talk about this legal case, which is ostensibly dealing with a sort of a narrow instance within the law, but really is ultimately about trying to find the law, I get unconstitutional under the California, or is it just simply illegal?
Well, the effort will be to try to find the law unconstitutional, at least in California. If there was a previous effort to try to get the mandatory mediation section of the law declared unconstitutional, and that got up to the California Supreme Court, and the California Supreme Court said, no, it's perfectly constitutional, no problem. The growers, when there is a case right now in Bakersfield in which the Wonderful Corporation, which is really this giant agribusiness complex, is challenging.
We should say that's the name of the corporation, not your description of it.
That's right.
When I first read it, when I read your piece, I saw like the wonderful lawyer, and I thought that's an odd way to describe an attorney. But
well, you know, I have to admit I did play around with the word in the course of the article. But the Wonderful Corporation actually is about $4 billion in sales every year, and people are familiar with the pistachios, or with the Fiji water, for instance, which also belongs to the same company. In any case, they are challenging the certification of the United Farm Workers Union for part of the company, a nursery that grows rootstock for grapevines, which has about 600 workers. And they are challenging that in court in Bakersfield in California. If they are successful in court, then the union would lose its certification and not have the right to bargain. But because the board has said that the union did have majority support, or does have majority support there, the company is still obligated to bargain even while the case is proceeding. You know, if the case gets up to the California Supreme Court, the question will be, again, is this section of the law legal under the California Constitution or constitutional? There is some suspicion that the growers want to take the case into federal court. And the reason for that would be that the ultimate end of that case would then be the US Supreme Court. And the US Supreme Court has proven itself to be very unfriendly to the concerns of farm workers and farm worker unions, and for instance, knocked out a previous section of the California's labor law, which allowed union organizers and workers to talk to each other on the grower's property. It was called the access rule, and the Supreme Court ruled that this was a violation of the private property rights of growers. So if the wonderful corporation is able to get this case into federal court and up to the Supreme Court, that would be a big threat to the law itself.
What would be the hope of this wonderful company like, how many let me be explicit about this. How many conservative judges will they find in the circuit courts, the federal courts, or district court, I guess, to start with, in California? I mean, you're really having to gamble that you're going to find somebody who's going to find in favor of the plaintiff at this point, right? I mean, because the Supreme Court won't necessarily take an appeal, but I guess maybe they're fishing for it on some level.
Well, you might think that. If the wonderful corporation loses in federal courts in California or at the Ninth Circuit Court of Appeals, then they simply appeal it to the US Supreme Court. So either they win at a lower level or they lose and then appeal. And in a way, you might think that their lawyers hope that they would lose at a lower level because it would get them where they want to go. The wonderful corporation, when they went to this small hearing in this small California city, Bakersfield, they brought with them 10 lawyers. So you can kind of see the resources that the corporation is putting into this. And wonderful corporation does have a lot of resources. Again, they had $4 billion in sales last year. And the company is owned by a couple, Stuart and Linda Resnick, who are sort of big political players in Los Angeles, and they're together worth about $10 billion. So they have the resources to be able to do, legally speaking, pretty much whatever they want. And that's one reason why there is a lot of suspicion that they want not just to eliminate the United Farm Workers Union as the union for the workers and don't have to bargain a contract, but that their target actually goes beyond that and is actually the invalidation of the law itself.
So regardless of where we are in the status of this case, this is something that probably we're going to be talking about. Maybe, I don't know, if it gets to the Supreme Court, it may take a year or so, but it's conceivable this gets kicked up to the Supreme Court. And this is the type of case that the court would be looking for. In the event that they found that the court was to find that this was unconstitutional relative to California, would that inhibit the ability of the National Labor Relations Board to create rules, theoretically, like CEMEX, to go forward? And there's been some talk that maybe the National Labor Relations Board will ultimately make a rule to the effect of stalling on negotiating in a contract constitutes an unfair labor practice, and therefore that's when we would do the forced arbitration or mediation. What's that relationship? I mean, could the court extrapolate, the Supreme Court extrapolate from this California law into federal law?
Well, I don't think anybody really knows the answer to that question.
Right.
You know, the Supreme Court recently has been taking cases which have a pretty limited purview and making rulings which extend beyond the questions that the cases themselves pose before the court. But I think it's also, what you're asking is also kind of a political question to me. The reality, I think, is that California's labor law for farm workers is a very pro-worker law. And it sort of sets a standard for labor relations, first of all, for farm workers, as we see in New York State following suit. And I think there are farm worker unions in other places that are thinking of trying to get their legislatures where they have the political possibility to do that, to pass similar laws. But it also sets a standard for federal law. You know, the fact that farm workers, for instance, are able to impose a contract on a grower who will not negotiate. You know, you can imagine workers in the private sector all over the place, like Starbucks, for instance, or let's talk about Amazon. How long ago was it that those workers in Staten Island voted for the union there, right? And yet there's no negotiations even in sight with Amazon. So this law and its ability to impose a contract on growers is raising questions in the minds, certainly of Amazon workers, I'm sure, and also people who are looking at ways of changing our labor law to make it more effective. We've had decades of U.S. labor law, which essentially has favored employers, really. Mm-hmm. You know, workers who were fired for their union sympathies really have no recourse. There are no fines that can be imposed on an employer for doing that. If workers get fired and then have to go and take a job while they're unemployed, the employer gets to deduct the wages from the other employer from any kind of back wages that they owe the worker. So really there are no penalties for violating federal labor law. And the new National Labor Relations Board is trying to sort of begin to put some penalties into place and to change this decades-long kind of slide into a sort of pro-corporate labor law. And I think because we do have this law here in California, and it does have things like card check and mandatory mediation. Another thing, it has quick elections for when you do have elections. If you file a petition for an election, it has to happen while the workers are there. And in agriculture, that sometimes is a pretty brief period of time. So that's a good thing too. You know, right now, as you pointed out at the beginning of the program, the length of time between the time when workers sign those cards and ask for an election under federal labor law and the time that they actually get the election, that can go on for a very long time. And in the meantime, of course, that's when the anti-union campaign takes place. So the idea is to shorten the process, and that's what this California law does. And I think it provides an example for how we could change federal labor law.
David Bacon, we'll put a link to your piece in The Nation magazine on this assault by Big Ag on California labor law. Thanks so much for your time today. Really appreciate it.
It was a pleasure. Thank you.